started on this session that, again, was going to be for the autumn annual meeting on government use of federally funded innovations. It is much more complicated than one would think. And the first person that came up with this idea actually came out of Nebraska. And so I will allow them to introduce themselves.
Hi, I'm ZANE GERNHART. I'm a Senior Technology Manager at NewTech Ventures. NewTech is the Technology Transfer Office of the University of Nebraska-Lincoln. And so my role at NewTech is primarily to handle licensing of our engineering and physical sciences portfolio from across campus.
Thank you. And Cheryl?
Yeah, hello, everybody, and welcome. I'm CHERYL HORST. I'm the Associate Director and IP Counsel at NewTech Ventures. As Laura mentioned, we posed this topic primarily because we didn't know much about it, and we're running into situations where we had some difficulty. At NewTech, I'm managing the patent portfolio as well as agreement review.
And last but not least on the panel is Mike Paulus.
Hi, my name is Mike Paulus. I lead the Technology Transfer Office at Oak Ridge National Laboratory. And we have kind of an interesting space here. We, as a nonprofit, we are a bi-dole entity, so we use the normal university types of license agreements that include government use licenses. But at the same time, we're a federal facility, so we also take advantage of the government use license. So we get a chance to see both sides of this.
Okay, great. And my name is Laura Schoppe. I'm the founder and president of Fuentech. And before that, I worked in the defense industry, doing submarine and surface ship combat systems at GE Aerospace. So we were on the contractor side of this equation, both in developing innovations, but also in using them for government contracts. I also have worked with NASA and other government agencies, so I've seen it from a variety of different angles. So we are, as a group, going to share some of our experiences and our insights in this particular topic. So I'd like to get us started with the basics. So what constitutes the right of the government to these innovations that were developed with federally funded dollars, but at other institutions? What rights do they have on that? Well, there is a CFR 37401, and the particular portion of that that is relevant for this talk today basically lays out that the federal government has a non-exclusive paid-up right to use the innovation that was developed with their dollars, or with any federally funded dollars, on their behalf or directly. And so we're going to look at different scenarios as to what that means and how that impacts things. There's also a code that stipulates what language they need to have in those agreements in order to basically give them that right. So many of you probably have read or may have even participated in the NIST Green Paper, which was looking at what was going on with federally funded innovations and how can they make it more efficient and more effective. And this topic was one of the things that they looked at. So one of the aspects that they recognized was that it's not very well defined how the government stipulates their rights to use and their march-in rights, and that it creates some ambiguity in what is interpreted both by the people that would use that technology, but also those that are the innovation holders. And so they made recommendations, and I put that in quotes because as a green paper, they can't actually say this is what should be done. So they did it more as an observation, that the government use aspect of it really should be limited to be specifically for direct use by the government or a government contractor in performance of developing a product or service for the government. So really reining in how that language is provided, because right now, as we're going to see as we have these discussions, it's pretty broad and pretty vague. They also felt that the scope needed to really narrow it down to not include third parties and how that was going and how that right conveys. So how do they exercise? How does the government exercise that right? What does that really mean? So there's really no paperwork involved, and because they don't have to sign a piece of paper that says we're exercising our right to use this innovation, there's very little statistics and very little information that's gathered on this, both from the side of organizations such as yourselves, universities, or other research institutes on how often their innovations are used, but also how contractors might use that. So we really don't have a lot of information on the impact of this. And notification, you may or may not even know whether your innovation is being done. So you certainly are being used. So if the government is using it directly, they don't have to say anything. But if they do want somebody else to use it, presumably they would tell you that. And again, we'll get into a little bit of that with the scenarios that we're going to be discussing. Now, what's the practical way in which you might see that? Normally what we would see is that if a license would have a 5% royalty rate on it, that when this is being implemented and it's for government use, they don't pay that 5% royalty. But let's hear from our experts on a little bit more of what their experience is in how the government actually exerts that right. So Mike, your perspective as a GOCO, a government organization but corporate run, how typically does the government exert their rights?
So I visited with our friends at the Department of Energy side office and asked them, how do they take advantage of their government use license? And we see two ways. The first is when a request for proposals is released for some kind of a contract with the government. In most cases, there will be a section that includes royalty information. And they ask, will there be any fees to the government that are based on royalties that are paid to a third party? And if so, who is that third party and what is the intellectual property? And then DOE will take a look at that and check to see if the underlying patent application includes the disclaimer that there are that a government use license attaches, and then expect to see a discount as a result of that. Secondly, when we issue a contract, or when DOE issues a contract, it very often has an authorization and consent clause that basically says that the contractor, in the course of performing work for the government, doesn't need to worry about whether or not it is infringing intellectual property. That if there is a lawsuit, then the government will stand in the contractor's place and defend. And then should that happen, the very first thing that the government will do is look at the underlying patents that are the basis for the infringement claim and check to see if a government use license attaches.
Okay, great. And CHERYL, I know you reached out to a variety of people to understand their experience with exerting government rights. Tell us what you found.
Yeah, so, being a university that doesn't encounter this very often, ZANE and I reached out to a number of institutions, and it was really interesting. There's definitely a varying level of understanding of how this is supposed to work. So from the university's perspective, many universities were doing a full-fledged license agreement when they were essentially giving a technology back to the government that they already had rights to. One school did an elaborate legal review of whether or not they needed that agreement and came to the conclusion that they really didn't. And they've now moved to doing a really short confirmatory letter. So it's a 1 or 2 pager that stipulates the technology is going to be used by the government. So, you might want to do that because it's helpful for measuring impact, but at the end of the day, it's not really necessary. And then on the flip side, we talked to a federal agency, not in the defense space, but our campus received a request from a federal agency to obtain a technology from another university. And it was really unclear, even from the standpoint of the federal agency, how this should work. They seemed to have an idea that there was some template or a process somewhere that we should be following. But at the end of the day, I think it's true, there really isn't something out there. So it just highlights the uncertainty, and without having a really clear path, I think it's not as efficient as it could be to move these technologies to the federal government when they in fact have the right already.
Yep. So the way we're going to approach this, since there is ambiguity and there is a lot of different ways that things can be interpreted, is we're going to lay out some hypotheticals and talk to the panel about whether they would pursue patenting and what sort of licensing strategy they would do in each of these scenarios and what the pros and cons might be, to just give you some ideas and some examples to be able to move forward with your own strategy. So the first one is really a pretty basic, simple, direct one. And there's 3 decision points that happen when you're dealing with federally funded innovations. The first is whether you elect title or not, and that's an activity that goes on between the research organization and the funding federal agency. Then you decide, if you do decide to elect title, do you patent it or not? And then if you do patent it, what's your licensing strategy? So we're going to lay out these scenarios and talk to the panel. So in this very first one, we have the research organization, so we're going to say it's our panel members, have the technology in question, so they're the licensor. There is a company that is interested in that innovation for a government use only application. And so the first decision point is, do you elect title? So if there's only going to be a U.S. government application, Mike, typically, would you elect title?
So it depends on the application. I would say in general, we probably would. And the reason is that in addition to having our bi-dole relationship with the Department of Energy, because we are a Department of Energy mission laboratory, we also want to be able to demonstrate that the work that's being done here is having a positive impact both for the private sector and for the government. So we would probably elect title and use this as a source of a metric that we could use to report back to DOE that, in fact, our scientists are producing work that has potential value to the federal government.
Okay.
At Oak Ridge, we elect title to about half of our inventions. At the end of the day, that's a budget-driven number. And then we have a kind of an interesting quirk that periodically our people that are working in classified space will file a classified invention disclosure. And those are filed. I'm sorry, those are prepared but never filed, and then it becomes effectively patent rights that last forever.
That's probably a somewhat unique circumstance, although there are some universities that do classified work, so they may fall into that category as well. Cheryl, how about you? When you guys encountered this scenario, what's your decision process? Do you elect title or not?
Yeah, so I mean, generally when we elect title, we do it almost at the same time that we make the decision on whether we're going to patent something. And of course, that's because universities are, faculty are driven to publish. And so oftentimes we're getting technologies that are at the brink of publication or they already have been published. So when we make that election decision, it really is looking at a tech assessment around the invention. So is it patentable? We do a market analysis and then we look at the commercial potential. And if we find that there aren't barriers, and in this situation, if we think we can recover our patent costs, then we would elect title and generally file the patent shortly thereafter.
Okay. And my experience has been that for NASA, for example, the organizations that had the IP, if they think it's a government use only, they will often not elect title. And then what NASA will do is they typically will publish it in tech briefs just to get it disseminated. And back beforehand, it was to make sure that they were not precluded from getting any patents. Now, next part of the decision process is, do you patent or not? So Cheryl, you just kind of walked through that if you do elect title, you are going to go ahead and patent. How about you, Mike? Do you guys always patent?
We will. If we elect title, we will patent. And in fact, our understanding is that if we elect title, we have an obligation to patent. That's the commitment we make when we do take title to the invention.
Yeah, and I think that's probably true for all the organizations, the way the regs go. You do have to act within a certain period of time. Okay, so you've elected title, you've pursued patent, and now are you going to license to this company that says they've only got the government use, they're going to sell directly to the U.S. government. What is your patent strategy? Mike, let's start with you.
So we'd be happy to license to a company that does initially plan to work with only the U.S. government for a couple of reasons. One, again, it gives us the ability to demonstrate that we're having impact. Secondly, you never know when a government application is going to morph into a commercial application. So we like to give our licensee the opportunity to do that. And third, it creates a possible business opportunity going forward. So we would do it. We would normally structure it so that there's a relatively modest upfront fee, basically just to preserve their future commercial rights. And then we would bake into the license reporting requirements, so that we'd ask that they report to us their government sales. That gives us, again, ability to track impact. And then hopefully they'll be able to morph it into a future commercial business.
Okay. And Cheryl, how about you guys? What's your strategy?
Yeah, so if we pursue patent protection, then we're generally going to try to enter into a license agreement to recover at the very least those costs. I will mention, though, that we've seen, it does create a market uncertainty for the licensee because they're anticipating that they're going to be able to license or sell this to the federal government. Meanwhile, the federal government could technically have another company that they work with who can have access to the patented invention and not work with licensee, right? So we find that it does create a little bit of uncertainty. From the licensing standpoint, though, Zane is going to talk about some situations we've seen.
So I just wanted to mention here, I think it's really important as a tech transfer office in a scenario like this to really verify what funding contributed to the invention. So you can imagine a case where you have a device that's disclosed to you that really has 3 or 4 distinct components to it. Really, you want to go back in this scenario and talk to your faculty and make sure that all of those components were developed as a result of the federal funding. Because if they come to you and they say, well, actually, the first component of this device I developed without federal funding, I developed it with university funding, let's say, and I put that in my preliminary results, and the grant was really just to develop the second, third, and fourth component of the device, that might change your filing strategy, and you might want to talk with your patent attorney about, having a separate patent in some cases for that first component versus the other components. And then when you license that technology to the licensee, just making it clear that part of this technology was developed with federal funding, but part of it wasn't, and that we expect to receive a royalty on the portion of the technology that wasn't developed with federal funding. So I think this is a practice that most technology transfer offices do a good job of, but in this scenario especially, you want to dig into the details and find out, was federal funding actually used to develop this invention?
Yeah, and then I'll just add to that, it's really important to have conversations with your inventors about this as well, so that they understand and you're setting up the expectations for them. As professionals, we struggle with how this should work, and so you can imagine, right, that our inventors additionally are struggling with this concept that they may get federal funding, invent something, but then we may not be able to pursue it for one reason or another. But ultimately, if it goes back to the government, that makes it really challenging for us.
Mm-hmm. So what we've heard a little bit so far is that the patenting strategy you need to be very careful of and look at where your funding for each aspect of the innovation goes, and also reporting and tracking what's going on. Okay, let's go to the next example. What happens in the same sort of circumstance, but the company decides they don't need to get a license from you and they're just going to practice it? Does that change your perspective or your behavior? Cheryl, let's start with you.
Yeah, so, patent filings are really important for our university, as they are for all. We have a 5-year strategic goal that includes increasing our number of patents. And we recognize that that is an indication of entrepreneurial activity and successful tech transfer activity. On the flip side, in these types of cases, we really don't need to secure patent protection, and this technology is going to see an impact regardless. Additionally, we're really not going to get our money back for investing in the filing. So we often will not do it in this case.
Okay. And Mike, how about that bridge?
So it depends very much on the market space. If there's clearly no application other than a government use application, then we likely wouldn't file. If we could see over the 20-year life of the patent that there could be a commercial use, then we might take a flyer on it. One thing that does happen from time to time is a company will reach out to us and say that they intend to use our intellectual property for the benefit of the government under the government use license, and ask for an acknowledgement. That particularly happens when there's software associated with the invention, or if it's just software only, and they need for us to release the software in order for them to do the work. And in that case, we'll do a government use acknowledgement that lays out what the company can and can't do with the intellectual property, and places limits on that it must be done specifically for the performance of work for the benefit of the government, and gives us some control over it. And the other thing it does is it gives us some visibility to the use of our research outputs by government agencies, and for us that's very beneficial.
So when you're aware of the fact that the company intends to use the innovation but doesn't have any interest in pursuing the license for it, then you can ask for some sort of acknowledgement and paperwork. But if you're not aware of it, then obviously there's not a whole lot you can do about that. That's correct. And honestly, software is the driver, but we have something that the company needs to have in order to do the work. Mm-hmm. Okay. All right. Now let's make things a little bit, whoops, did I go the wrong way? Sorry. A little bit more complicated. Rather than just being government use, now it is government use and a likely or potential future commercial use. How is that changing your strategy for patenting and or licensing from what we just discussed? Zane, I know you recently had an experience with this. What did you do?
Yeah, so in this case, I think we would definitely patent and elect title. Really here you have to ask yourself, how confident are you about the commercial sales? And that's going to change your strategy on how you license this. So if you feel very confident that there's a high probability that you'll have commercial sales, in that case, you might be fine structuring the license agreement in a way that you're mostly getting paid through a royalty stream that's coming later after the product is commercialized. However, if you look at this and you say, within the organization that you're not very confident that there's going to be those commercial sales, then you might want to look at structuring the license differently. And you might want to think of structuring it in a way where you give them rights to commercial markets and to the U.S. government sales, but you look at more for an upfront fee. So you're trying to get that money not through royalties, but through negotiating a higher upfront, through trying to get your patent expenses reimbursed. So at the very least, you're breaking even on the technology. And then one strategy we heard from a number of tech transfer offices we talked to when we were preparing for this presentation is to charge a yearly maintenance fee to keep the license active. And that fee would be in no way linked to royalties or to sales of any kind or sales milestones. It's just a flat fee that they pay in order to keep the license alive. And so those are different ways that you can get paid for this if you're not entirely sure where the royalty stream is going to be coming from as the technology develops.
So, Zane, in the cases that you've just outlined, do you always want to include the potential commercial sales in that license right from the start, or do you want to set them up to just do the government aspect of it and they have to come back to you if they do commercial sales?
I think you need to still verify and kind of do your own due diligence. So talking to the company, and asking them, clearly there are some companies whose business model is only to sell to the U.S. government. And there are others that it's a mix, they'll sell to the U.S. government and to commercial markets. And then also looking at who else is out in the market besides that company. Is there another likely licensee that might be more likely to sell to commercial users? If it's a company that sells to both the government and to commercial users, then I think you have that conversation with them. But I would be more likely to include both sets of rights in the license agreement initially in a case like that, especially if there's not another company out there that's likely to develop this and sell it to commercial users.
Okay. And Mike, how about you? How does your strategy change?
So I tend to agree with what Zane has described. You do want, if you're licensing to a company whose business model currently is exclusively to do business with the U.S. government, then we like to hold back the commercial opportunities so that if another partner comes along, we have rights to license. What we like about this a lot is if the government is a customer, they're de-risking the technology and validating it. And over time, that increases the probability that it could be adopted for commercial use if it's an appropriate technology. So, it's as always, you look at it case by case. You want to establish a relationship with the licensee, in my opinion, even if they're only working with the government, so that you have visibility to what they're doing. You want to take advantage of the fact that the technology is being used, so that over time there may be commercial opportunity, and you want to, as much as possible, maintain control of the commercial rights if it looks like this particular partner isn't going to be pursuing a commercial opportunity. And we tell them that if your business model pivots and you want commercial rights, then you can certainly come back, and we'd be happy to have that conversation.
Okay, great, thank you. Now let's complicate things again. In this case, the licensee is not just going to be selling to the U.S. government, but they're also selling to foreign governments. Does that change the situation? Do they still have all the same rights as they had before? Cheryl, let's start with you. In this case, it's they're selling it to the U.S. government, and then there's going to be a foreign government.
Yeah, so it really depends. It really depends on whether the licensee is directly selling to foreign entities or the government, or if it's going through the United States. And this is an area we've seen a lot of confusion around as well in terms of vital and understanding. If the licensee is going to sell to a foreign entity without the U.S. government being involved, then we want to make sure in our license agreement that we have really clear expectations about reporting and auditing and export control and compliance. Sometimes the way we might structure this, which ZANE has talked about previously, is to do just the license to the U.S. government initially, and then have the entity come back and renegotiate if they plan to do something with a foreign government. It seems as though the Bayh-Dole Act allows for the U.S. government to sell to a foreign government without paying a royalty. So that's something to keep in mind, and I guess open for discussion when we finish the session. I think that'll be a question that people want to talk about.
Yeah, so Mike, do you want to clarify a little bit about when it's okay to have the foreign government discount and when it's not?
Sure. So in terms of the discount, the perspective we've taken is if the sale is on behalf of or for the benefit of the U.S. federal government, then the discount would apply. And if it's not, then it wouldn't. 5 years ago, I would have said we would enthusiastically pursue something like this, because the ability to have a revenue stream based on sales to a foreign entity was attractive. To date, it's much less so, particularly for a federal agency. Interactions with non-U.S. entities are increasingly under scrutiny, and so just from a relationship with our sponsor perspective, we're finding that we're much more careful about entering license agreements with non-U.S. companies, and even more careful about entering agreements with companies that are selling to non-U.S. governments.
Mm-hmm. So for clarification, the code and the CFR stipulate that the U.S. government can extend the discount or the royalty-free paid-up non-exclusive license to international governments and their entities if there is a treaty or an agreement in place that allows it. So it's not just a blanket. If it's some other foreign government, they get the extension of the discount. It has to be within a treaty. So you want to be careful about the language and look at what's in place for that government entity, because otherwise you have free reign to go get your royalties. Now that's separate from Mike's comment about whether you want to be selling to foreign governments or not. So we'll leave that for a different discussion. All right. Now this is actually probably a more common scenario that you may run across. So your licensee may be selling directly to the U.S. government, but they're also selling to a prime contractor who might be selling to the U.S. government. So to give this a little bit easier perspective, your licensee is Northrop Grumman, and they need your innovation to go into a component that makes up their weapon system. They turn around and sell that weapon system to Lockheed, who puts it into the F-22 Raptor, and they sell that to the U.S. government. Do they get the pass-through of the discount? Yes or no? Zane, you want to start off?
Yeah, so this one is a really hard situation for tech transfer offices to form a strategy around, because you won't always know, especially in that bottom route where the licensee is going through a prime contractor, that they're selling to the U.S. government. And so I think first off, to back up, in the case of our office, we would likely patent and elect title, especially if it was a technology where we thought that there might be some potential commercial use down the road, and we didn't know that the government was the only end user. But again, it's really not going to be clear to the tech transfer office, because you license the technology to the licensee, and they report sales back to you, to the U.S. government, which you probably aren't going to be able to get any royalty on, or shouldn't. But then they report sales to a prime contractor, and that prime contractor might sell to the U.S. government, they might sell to commercial end users, and you might not have any visibility into that and to where those sales are going. So tracking that situation is much harder for the tech transfer office than trying to anticipate that. And one of the things that we found from talking to a number of other tech transfer offices is that this is really a huge point of confusion. Where does the responsibility lie for tracking these royalties, and whether or not you should receive them? Does it lie with the prime contractor? Does it lie with the licensee? Does it lie with the tech transfer office? We heard a lot of varying views on that question, and it would be interesting after the presentation is finished to hear from others. But I think it's important for the tech transfer office to have a good licensing template that has language in it when you do have federal funding, that it makes it clear to the licensee what their obligations are, and that it puts as much of the obligation for reporting and enforcing that provision on the licensee as possible.
So, Mike, does it, given what Zane just said, that this is rather gray area and people interpret it differently, from your perspective, how do you guys interpret it, especially whether Northrop tells you that they're selling it to Lockheed, who's selling it to the government or not? Does it matter to you?
So I agree. This is murky. I chatted with our IP attorney that has a little bit of a pro-government bent, and his take would be that the government use license would reach all the way through. That if in fact the prime contractor was making something using products from the licensee strictly for the purpose of selling to the U.S. government, then the deal, or our local attorney's view was that government use license would reach through. The challenge is, the reporting is murky, and certainly the prime contractor, or certainly the licensee, has a motivation to flag as many things as possible as being government sales so that they don't have to pay royalties. So from a tactical perspective, I think it's important to have strong audit clauses in your licenses so that if you're suspicious that the reporting is incomplete, then you have a vehicle to go do a little bit deeper dive.
Okay, thanks. So as you can see, this can get super complicated, and I think what we just talked about and the scenario that's up now of it can go in so many directions is exactly what NIST was concerned with, and why they were looking for a narrowing of that language and to be specifically to the first level of sales. So third-party sales would be excluded, and that would alleviate that need for, does it extend all the way through as Oak Ridge currently interprets it, whether you know it or not, and who has the responsibility of reporting and deciding whether that should extend all the way through. So in this world of it can go in so many different directions, let's kind of wrap up with the panelists of these types of scenarios. What are the things you should be looking for in terms of when should you patent, yes or no? Let's start with that one. So Mike, how about you start with that first? Just, you have government use, but you don't know where it's going to end up. Recap for us what your strategy would be.
So most of our technologies are very early stage. And in general, if we think that they have utility, and the fact that there's a government use kind of validates that there's utility, we would typically err on the side of going ahead and electing title and patenting. And then when it comes to license, we would like to get a license in place because even if the royalty stream isn't significant, it has other hooks in it. And for us, we're particularly interested in reporting obligations because it gives us the ability to go back to our sponsors and affirmatively state that we're having impact with our research, even if the customer is a government customer rather than a private sector customer.
Okay. And Zane or Cheryl, what's your general recommendation on what the strategy should be, since you don't know where it's going to end up, especially when it comes to the licensing part?
Yeah, I think we would generally agree with Mike. Most of our technologies are very early stage, and we can't definitively say that the government is going to be the only end user. I can't think of very many technologies we've ever put through our assessment process where we've said with certainty that the government was going to be the only end user. And especially because it's early stage, it really has that potential to transition over to commercial use at some point over the life of the patent. If we do patent something, then we definitely want to try to license it. That gives us a potential mechanism to get paid for the patent expenses that we've invested in it, and potentially, as Mike said, to get paid in the future as it transitions over to a commercial use.
Yeah, and one other thing I'll add to this point of the conversation is it's so important to have a good relationship with your licensee. And that's not just at the point of doing the deal. It's, every few months or annually, whatever it is for your office, just making sure that you are touching base with them, that you're getting your annual reports, that you understand where they are and what they're planning to do with the technology.
Okay. So generally speaking, I think the recommendations that we're hearing from the panelists is when it's practical, you want to get that license and you want to be able to monitor and control it and get those metrics. I mean, not just from the perspective of being able to report it back to the government, but also to your other stakeholders as to the funding that came in and how that's impacting. You're already collecting a lot of the metrics, and this does not nicely fall into licensing revenue, but it would count towards a license. And it could be used to help explain back to the government that there is more value coming out of the research that they funded than just the licensing revenue that could be garnered if it was commercial sales. You also want to make sure that you're getting as much of the reporting and the data as you possibly can, so making sure that that's in your licenses. Here's some sample language that we pulled together. I'm not going to read it, but we are going to make the slides available as well as the recording so that you can pull from this. If you had not currently had language in your license agreements, you want to make sure you do if it's federally funded, because you do have an obligation to do that, and you want to push the onus on the licensee to be aware of the fact that there is this pass-through so that they can notify you when it is occurring, because you have no visibility into who their client is going to be unless they're telling you that. So let's wrap up with some questions. If the attendees have any questions, you can use the chat button, but I've got some to kind of start us off with. So Cheryl, what has your experience been with licensees on this topic? Have they complained at all about having to deal with this government use aspect?
Yeah, we've certainly, and maybe Zane can talk about this because he has a technology he's currently working on, but we certainly see a lot of confusion, misunderstanding about how it works. Is the licensee going to be able to financially benefit if they take something that has federal funding? So just lots of confusion around it. I don't know, Zane, you want to talk about a particular case?
Yeah, we've had a few cases where this has been a problem in the past. I think in general, depending on the company. So some companies are used to working with the government all of the time and working with universities, and they're probably familiar with this. But some smaller companies that you might work with that have aspirations to be a government contractor, they might not be as familiar with it. And so when they read this in your license agreement, they might flag it as something that's not acceptable to them, or that they're just completely confused about and can't understand why it's in there. And you really need to be able to explain it to them. And then I've had a couple of cases too where we're licensing essentially a device that has many components to a contractor that is going to be providing services to the government. And in one of those cases, one of the technologies was actually developed several years earlier, and it did not use government funding, so it used university funding that the faculty received as part of a startup package. And then a second piece of that technology was developed a few years later by the same faculty member, and it did use federal funding. But in that case, it was nice for us because we could explain to the licensee that we're not collecting a royalty on the federally funded portion of the technology, but that we would plan to collect a royalty on the part that was not federally funded.
Okay. Hey, Mike, do you think that you have an obligation to tell the licensee about the government use aspect of it?
We do, and certainly we have literature, and as a part of the conversation with them, we point out that clause and make it clear. We don't have a lot of complaints about it, to be honest, and it may be because this is a federal facility that there's more of an acceptance that we're going to have that constraint. But we do think that there's a transparency obligation with any negotiation with the licensee, and in fact, the license has a clause in it that makes it explicit that there is a government use license that attaches to all of our intellectual property. And that may be one difference that we have relative to university. We don't have any inventions that are not associated with federal funding. All of our funding is federal, and even if it's not, because it comes into the lab, but it's then managed by the laboratory, it becomes federal. So all of our inventions will have a federal use or a government use license attached to them.
Okay. Do you have a recommendation, and Zane, I'll start with you and Cheryl. Do you have a recommendation that if you do think that this is primarily a government use license, and I know you've mentioned some strategies, do you have a recommendation that the licensing structure should be more upfront versus royalty? What are some ways to help ensure you get that financial back? Because I want you to kind of repeat that, because I think it's such a core part of the strategy.
I think as much as you can. And so there's an important part to this that really, in order to receive any upfronts, you're in some ways going to have to verify that there is a potential for commercial use at some point. Because if the licensee is sophisticated at all, they're going to figure out that, well, if I'm only ever envisioning selling to the US government, I can just have the US government grant me a license to the technology and I can use it without ever talking to the tech transfer office. But if the licensee is potentially going to have commercial sales later, and you're not entirely sure if it's going to be a big part of their business plan or not, then you might really want to go for a bigger upfront if you can during the negotiation. Try to get your patent expenses reimbursed so that you're not in the hole, so to speak, on the technology, or so that you at least break even, and making sure that you include provisions where you would be paid a yearly fee to keep the license alive, just in case you never are able to collect those royalties on the commercial use.
So it's a great strategy from your end, but if the licensor is, or the licensee, sorry, is savvy about their rights to gain access without a license, they might just walk. So you've got to balance that negotiation strategy with keeping them engaged, right?
Correct. Yeah, you'd really have to verify that there was some potential commercial use that was appealing to the licensee in order to start that negotiation.
Okay. All right, we've got a couple of questions from the group. Mike, I'm going to direct this one at you. In which FAR clause, if any, do the regulations specifically prohibit the licensor funding recipient from collecting royalties from licensees who sell products to the government that are covered by a patent on a subject invention. And if no such FAR clause exists, do your positions come only from the interpretation of the general clauses that we cited?
Sure, and Laura, you and I were both looking for a FAR clause, and I was unsuccessful. The interpretation that we take, and again, this is from the perspective of a federal laboratory, is that the benefit that a licensor derives from IP is the payment of a royalty. And if the government holds a license, then they don't need to pay for that benefit. And so it's a clean way to ensure that the government is able to take advantage of its government use license. But I can't point you to a specific clause that says that is the specific way in which the government exercises its government use license.
Yeah, my experience from NASA was that when they discovered it after the fact, so if there was a sale and the licensor received a royalty, they can go back and say, we want that money back. So that 5% gets refunded back to the government, to the licensee, who refunds it back to the government. It's just such a rare occurrence that they reach back and do that. So there's a practical versus what the FARs say. Next question we have is, what if commercial use comes first? Is there a distinction to be drawn between the government explicitly contracting with the licensee for a product service covered by a licensed government-funded patent and a situation where the government is just buying such a product from the licensee off the shelf? Zane, you want to take that one first?
Yeah, I think this is an excellent question. This is a point of great confusion, I think, is what we found from talking to a number of different tech transfer offices. And I'm not sure that we have a firm answer on this. It seems like the majority of the people we talked to felt like if the government was the end user, they should receive a discount, or that you as a tech transfer office shouldn't be receiving a royalty on that. But again, can you track it, and do you know that that's the case depending on how the item is sold? I can't think of a good technology example, but if it's placed on a store shelf somewhere, for example, by your licensee, and the government happens to order a bunch of those, they might not be able to track that, or they might not report it to you, again, just depending on how it's sold. So I'm not sure that you would necessarily have visibility into that. It really just depends on the technology, how it's sold, whether or not the person who's manufacturing it, your licensee, is the person who's actually selling it. So there are a number of questions here, and it's definitely a gray area.
Mike, do you want to add anything to that?
So I agree with Zane. I think, strictly speaking, the government should have the reasonable expectation that it wouldn't pay royalties for products that are based on government-funded IP. But as a practical matter, depending on what the distribution channel looks like, it may not be possible to identify those. And I would say that the burden doesn't lie with the licensor. I would say ultimately the burden, in my opinion, would lie with the government to demonstrate that it has a right to exercise that government use license.
And therefore the implementation of that would be with the licensee, that the licensee has to report back to the licensor when they don't feel that they should pay a royalty, and prove that they've discounted the price to the government in that same amount.
Yes, and so our view is if they can produce a purchase order to the government, then certainly it applies. And if they can't, if there's an intermediary, then we need to do some digging with them. Okay.
Cheryl, do you want to add anything to that strategy?
I mean, I agree with everything that Zane and Mike have said. I think I'll just reiterate, the relationship you have with your licensee is so critical here, right? Because it's really impractical to know what's happening downstream. And if you have a good relationship, then you can be having those conversations on an annual basis, and then you can maybe be alerted to the fact that there is this government sale early on.
Okay. Last question I'm going to wrap us up with is, this is complicated enough for us in the tech transfer arena, where we're embedded with these agreements and the FARs and the regulations. How do you communicate this to your researchers? Cheryl, I'll start with you.
Yeah, and I talked about this a little bit earlier, and how it is really confusing for them. They want to see their technology have impact in the world. And so I think ideally we would have situations, and generally at New Tech here at university we do, where there's not just a government sale. The arena and the technologies we work with, often there's a commercial aspect as well. So I think that helps with the conversation with them in getting them to understand that while we may not be able to receive a royalty or any financial, payments from the government, we can still go after the commercial aspect. And then also having them think through, the fact that this is taxpayers' dollars and the federal money is coming to them and supporting their research, trying to get them to understand the reasoning behind why the government doesn't need to pay the royalty. I think that's helpful as well.
Okay. Mike, do you run into this challenge given the fact that you guys are a government facility?
We do, and then the challenge is that researchers are very busy, and if they invent something, they could self-determine that the only application is government, and then not disclose the invention, and we have no visibility to it. And as Cheryl said, if there's a government use, down the road, it's very likely that there'll be a commercial use as well. So that's something that we have to communicate. We do have one nice lever, and that is that per our prime contract with DOE, our researchers are obligated to disclose their inventions. So, we'll have a philosophical conversation with them about how government use could morph into commercial use, that we want to be able to track government use because that demonstrates the value of the research that they're doing. And then at the end of the day, they have to do it because it's required.
Right, which I think is probably true at most universities as well. It's part of their employment contract. Okay. All right. Well, thank you all very much for your time today, and thank you to my panelists for being willing to scramble and do this via web since we weren't able to do it live. And we will make this recording available for everybody that couldn't join us. And thank you very much. Have a good day.